Hello, everyone, and welcome to today's webinar on UK umbrella reform. For practitioners, end users, MSPs, recruitment agencies, and indeed umbrella companies, and possibly contractors, this is going to be exceptionally interesting. For the man or woman on the street, probably less so, but I've seen the invite list and I think everyone's going to be really interested in this topic. So we're going to cover what is the exposure, how potentially you can reduce your risk and make confident UK workforce decisions. Next slide, please, Pete. Thank you. My name's Conor Heaney. I'm your host for today. I'm the president at CXC EMEA. Bit of background here on me. You don't need to read it all. Most of it is true, and thanks to Pete, who is our marketing guru as well, for making me look good. Dad of two great girls, aged 9 and 6, and I've been with CXC now for the last 11 years. And we love a bit of workforce legislation and some workforce changes as a result of that legislation. Really pleased today to be joined by our co-host, who is Kurmani. Shaz, a very warm welcome
Thank
to
you.
you, and thanks so much for joining us today. For those of you who don't know Shaz is Associate Director at leading employment M&A law firm Osborne Clarke. I've had the pleasure of working with Shaz as a legal advisor to CXC, I think for the last 6 years, maybe seven at this point. Shaz and Osborne Clarke are exceptional at what they do. Shaz is an expert in IR35, agency worker regulations, MSC, and a whole host of other UK labour and employment law areas. Shaz was recently on our podcast, The Open Talent Report, and that is also a masterclass in all things umbrella. But we're really delighted to welcome you all today to our webinar. So before we start, just some brief housekeeping. We intend to have about 45 minutes or so just to run through the reforms, what they are, how they might impact your organization, some best practice, and then we've reserved around 15 minutes for Q&A at the end. If you have any questions, please put it in the chat. We're recording today's webinar as well, and we'll share that in the next few days via email. Please take notes. This is going to be really, really interesting. And as I said, we're delighted to welcome you all here and to have Shaz here with us. Okay, we're going to discuss the changes, where businesses and MSPs are potentially exposed today, and how you can protect your organization, your clients, and your supply chain. So, with that, Shaz, we're going to get into it. And it's really,
Excellent.
yeah. Well, we're really excited, Shaz. This legislation and regulation is really interesting to our audience and those that can't join us today. So, Shaz, just some background for those who are joining the webinar today. Why is the UK government pushing for the umbrella reforms, and what does it include?
Right, so this reform in particular is really about tackling tax avoidance in the umbrella market. There are wider proposals on the umbrella workers' rights in the Employment Rights Bill or Act now, but those aren't expected until next year. So what we have here is very much HMRC's tax project, and it's not in any way a holistic regulation of umbrellas. So before getting into what tax avoidance HMRC is trying to target, I think it's always worth reminding ourselves what umbrella companies actually do. They exist to employ contractors and provide PAYE payroll, benefits, and statutory protections. They're used where contractors and agencies want a simplified, scalable payroll solution across multiple short assignments. At their very best, they do add value, consistent PAYE, holiday pay, pension enrolment, insurance, fast onboarding, and a degree of working capital support by paying workers before the staffing company has been paid by clients. Compliant umbrella companies obviously then play an important role in the labour market. However, the government estimates that at the less compliant end of the market, we're looking at around a billion of tax avoidance that it wants to target. The sort of models HMRC is worried about and has seen for many years and has been playing whack-a-mole with for many years are things like the umbrella company models, where you fragment employment across multiple low rate entities, and doing that, you obtain or you try to obtain a national insurance contributions relief or avoid VAT. Disguised remuneration or artificial pay models using loans or credits or allowances to suppress taxable pay, or arrangements where workers look like umbrella employees on paper but are actually being paid gross via PSCs or self employed structures. All of this contributes in some sectors, such as healthcare, for example, to a race to the bottom, with some agencies and clients feeling like they have to turn a blind eye just to stay commercially viable. Where these schemes are operated, there's a big compliance burden for HMRC, which currently has very limited ways to recover the unpaid POA and NICs from the upstream parties who may have enabled or missed these arrangements. So then against that backdrop, we see the logic for Chapter 11 and the new joint and several liability regime. The legislation tackles HMRC's core problems in two ways. The first is it allows HMRC to target the entities with the bigger pockets through joint and several liability, rather than being stuck trying to recover against an insolvent umbrella company. And second is designed to make the market police itself. If agencies and in some cases end clients can be held jointly and severally liable, they have a much stronger incentive to take a firm line on tax compliance.
And Shaz, thanks for that. And that's something we're really going to focus on later in today's webinar is the joint and several liability, because I think the way you explained this really sets it out clearly, Shaz, when we spoke about this previously. And I think it's so important for our audience and others to understand what that actually means, right? Because
Mm.
it's pretty scary actually when you strip it back, right? And it's unusual for a civil piece of legislation, without getting too technical, to have that within it. So looking forward to exploring that further. Shaz, if we may, can we look at, what do the reforms actually include from your point of view?
Yeah, so I think when this was all first sort of teed up in the market, probably about 3 years ago now, there was a real fear that umbrella companies would lose the ability to hold the employer's PAYE reference, and that would have effectively destroyed the whole umbrella market. So it's clear now, what we do know from this legislation is that umbrella companies will still be able to hold the PAYE reference and run their own payrolls. So the real shift here is who is on the hook if tax doesn't reach HMRC. Under the new legislation, there's joint and several liability for any unpaid employment taxes between either the umbrella and either the top agency, so that's the one contracting with the client, or if there's no agency at all, or the agency is offshore, or the agency is connected to the umbrella company, the end client. That joint and several liability can bite whenever the umbrella doesn't pay tax in full, regardless of the reason. Late payment by an agency, historic tax issues, trading problems, none of that will show up on a standard payslip or payroll check. HMRC can choose whichever of the jointly liable parties it wants to pursue. It doesn't have to chase the umbrella company first. I mean, that can feel really harsh, but from HMRC's perspective, this is about actually collecting the tax. After years of hitting insolvent or low asset umbrella companies, it will finally have the explicit teeth to go after parties with bigger pockets. And I say explicit because really one thing that maybe isn't getting as much attention at the moment is the fact HMRC currently does have tools to tackle certain umbrella company avoidance problems, which it is actually using. It's just struggling to target that with as much verve as it wants to. So back to the future legislation. There is no statutory defence where the umbrella has deceived the supply chain. Even if the agency or client carried out checks, and even if it paid for market leading third party audits, or the umbrella company has provided you with fraudulent information, that's not a defence under this strict liability regime. The rules apply to umbrella company arrangements. In simple terms, that covers situations where an individual is supplied to personally provide services and there's an intermediary in the chain which either does employ them or which it is reasonable to suppose employs them. The definition of umbrella is deliberately wide to try and capture as much as possible and try and ensure there's less avoidance. It will include traditional umbrella companies, employers of record, consultancies and MSPs that employ individuals and second or deploy them, agencies that employ or engage on contracts of service, hire, train, and deploy suppliers, and any purported umbrella company. So, purported umbrella company is a new concept. It was introduced to cover arrangements where people in the chain reasonably assume that the umbrella or the entity is the worker's employer and paying them via PAYE, but in reality, that's not what's happening. In the final version of the legislation, this definition was expanded upon, with three very big case studies being quite heavily detailed. This definition seems to be being used to try and ensure there's no way that an umbrella company can essentially get out of being caught by this legislation by tweaking something within their offering. So, to detail the examples that are used in the legislation, a purported umbrella company could include companies telling agencies we employ these workers, but are actually engaging them via PSCs and paying them gross. Small umbrella type entities where the worker has a material or beneficial interest in the company, combined with structures that reduce or defer PAYE and VAT. And in a recent expansion to the definition, certain arrangements where a staffing company engages a worker as a worker, so an agency or PAYE worker, but hasn't provided the work finding services in relation to that individual. So, sorry, go on.
Well, sorry, no, please go ahead, Chaz. Go ahead. Thank you.
I think I was just going to say what's just as important is what's not caught by the new definition of an umbrella company. So, agency workers paid via the agency's own payroll, so contract for services, these remain under the existing agency worker tax regime, which already makes the top agency liable where there's supervision, direction, or control. There's the genuine PSC contractors subject to IR35 who are not brought within the umbrella rules by default. I mean, obviously, if they're a purported umbrella, they would be, but usually that's not the case. CIS subcontractors, including those using so-called CIS umbrella companies, are outside these rules, provided it's clear they are not intended to be employees, though the agency worker tax rules can still apply where there is supervision, direction, and control. So I suppose my main practical takeaway is everyone in the chain now needs to know who is actually paying the workers, on what basis. So really break it down. Is it PAYE, agency worker, PSC, CIS, self-employed, and whether what's being presented to you matches how that arrangement actually works. If there's confusion, deliberate or otherwise, over how workers are paid, they may be enough to bring the rules into play. And what remains unclear for now is how far HMRC will push the purported umbrella concept in practice and how aggressively it will use the joint and several liability against agencies and clients who feel they've done extensive checks. So many clients are still surprised, and to be fair, quite reasonably so, that even with thorough due diligence, they may still end up jointly and severally liable if the umbrella defaults.
Well, Shaz, like I'm just digesting that, and I've got a point or question, but I've seen a couple of points come into the chat from Carrie and Sophie. Hi, ladies, how you doing? So we don't have a deck today, but our intention is just to listen to Shaz. I've got a couple of points to run through, and we will be following up with a recording of today's webinar and a supplementary guide to accompany that. So there's tons of information in that, but really today we just wanted the focus to be on Shaz because she's bloody brilliant in this space. So, Shaz, the way you were describing that, it struck like this is quite an evocative image in my mind, but it's a bit like playing pass the parcel with a live grenade. Because if you haven't done your due diligence or you have done your due diligence, there's no real defense as this stands. Is that a reasonable thing to say?
Yeah, I'd say that's a very reasonable assessment of this. What I would say though is doing your due diligence does mean that you're less likely to end up holding a grenade. So all of this legislation only comes into play where there's a grenade. If you can ensure there's no grenade through your due diligence, you're fine. It's just your due diligence might not be enough to ensure there's not that grenade. So you could do loads and loads of checks and still be deceived. And if that's the case, then this legislation will still explode on your lap, to follow the metaphor through.
Yes, sorry. It was quite evocative. So, like, so Shad, is it like so? If I think back to the IR35 reforms, like I remember the HMRC were really staffing up to go after the public sector in the first instance, looking for irregularities and to make sure they were compliant. And reading the popular press and talking to some of your colleagues and peers in the legal world, that HMRC have staffed up to enforce IR35. Are you seeing or hearing similar from your contacts within HMRC?
For this umbrella legislation, or just
Yes. For the umbrella specifically, Shaz?
so every new budget, we have new announcements about HMRC staffing up to tackle tax avoidance. I suppose they don't necessarily focus in on what tax avoidance they're talking about. We just know from where they're deployed what they're targeting. IR35 has been a big one. So I think HMRC has taken a real interest in the past 5 or 10 years, probably five more than the 10, even more, on workplace taxes that are unpaid. And what we've seen in the past 2 to 3 years is actually HMRC has been catching up on umbrella companies that are avoiding tax already. So I think I mentioned this earlier. Actually, this legislation gives HMRC a really easy tool to go after, this market, but it already knows it exists and it's already trying to target it with the tools it already has. So this is a case of we're struggling with the tools we already have and we are targeting it and we've been, bashing our heads against a wall. Now let's just make this easier for ourselves. So yes, there is a lot of enforcers there. Yes, there are increases every year in who's enforcing. It's not necessarily particularly targeted at this umbrella legislation, but with this easier legislation to use, I suppose it may be somewhere we start to see enforcement. Never quickly with HMRC. They have a 4 year limitation period, which means usually we don't get to see any action until towards the end because they're so busy catching up on everything else they haven't done within their periods. So that's the reason for IR35. We're all anticipating lots of action after April or just before April when they finally go all the stuff we've been sitting on, and it will sort of be the same. We might start to see a bit more or hear a bit more noise, but we don't expect to hear lots of noise until 4 years from the date of the legislation. That doesn't mean they're doing nothing. That just means that's when we'll hear the big noise.
All clear, Shaz. And Shaz, just for the benefit of our audience, my understanding is the umbrella legislation comes into effect 6th of April 2026. So just a couple of months away, really. Is that correct?
Yes, that's correct.
Okay, the clock is
2 months,
ticking.
guys. Yeah.
It's exciting and scary at the same time. And I didn't think I'd be getting excited about a piece of UK labour law, but I think if we look at the potential impact of the reforms, you have to imagine, Shaz, that workers or contractors, whatever way they're best described, are probably likely to benefit from these reforms the most, which, let's face it, I think everyone on today's webinar would agree that's a really great thing. And something to be welcomed. And certainly we support that at CXC. I think it's to the good. But if we look at the other components within the chain or the supply chain, Shaz, like how is it like how are the reforms likely to impact, for example, the end user client, the MSP if there is one, the recruitment agencies or consultancies that are engaging the umbrella companies? What's your take on that, Shaz?
Well, I think for end clients, it may well be. We are starting to see some of them start to engage with this legislation, and it is always, in my experience, when we advise on this, the suppliers are the ones banging the drums, and eventually the end clients will get wind of it and start to notice. With IR35, if I'm honest, it was very much at the wire, or even after the time had passed, when end clients started to really engage with this being a problem for them. So, in a way, I suppose we should be grateful that some have started to notice this legislation before. Um, but in all seriousness, it may well be that they have a feeling that where there's an agency involved in the supply chain, it's a bit business as usual, as it won't end up being their problem. However, as I've already identified, there are situations where even with an agency involved in the supply chain, the end user may end up being the party with joint and several liability. So, for example, where an agency is offshore or connected to an umbrella company, even where there is an agency in the supply chain, the end user ends up jointly and severally liable. On this basis, we think end users should really want to start looking more closely at their contingent worker supply chains just to ensure there's no gremlins they're aware of. And it's a case of really like due diligencing your suppliers. If there's a supplier there, you have to be certain that they're not connected to the umbrella company below them. And there's so many actually that it's just you're so unaware of that it's just worth making sure you've gone through that diligence. I think the risk may, once end clients start to engage with this, start to become a bit much for a lot of them. And it may be the case that they decide to prohibit the use of umbrella companies or provide a small list of umbrella companies they'll allow, which will likely be from the larger, more easily demonstrably compliant providers. There may be some negotiating of contracts to ensure that the protections to them are as tight as they can be. Agencies engaging umbrella companies will, I really believe, increase their diligence on umbrella companies. I think we'll see an increase in third-party auditors and accreditations to help meet this compliance burden. Um, like MSPs as well, I think they'll also want to start narrowing their umbrella panels, relying on the bigger players or those that can prove their quality and compliance. Part of this might include umbrella companies emphasizing other benefits and improving their delivery of these. So the ones who can prove that they add so much benefit in addition to, the payroll, such as fast onboarding, fair holiday pay, responsive issue resolutions. And the more sophisticated and well-established umbrella companies will be the ones who are able to set up the processes that are transparent in terms of how they pay the workers in a way that agencies and end clients can feel confident. So we understand that there are lots of umbrella companies that have already worked quite hard at that. And in anticipation of this new regime, there may be even more like innovative approaches to supporting the supply chain. We'd be surprised if the bigger compliant players suffered a significant loss in their business. In fact, it may be a consolidation of the market and their market share grows, provided they get all their systems right. So we think it will lead to a natural decline in non-compliant umbrella companies. Umbrella margins with agencies might be revisited. So to ensure that agencies can fund the compliance burden, there may have to be a revisit to those margins. There'll be less scope for hidden skims, and in industries where there's been non-compliant compliance, workers may start to see lower take-home pay than before. This may lead to disgruntlement, but there should also be increased communications with contractors by agencies, as this upfront communication regarding take-home pay expectations, expenses rules, and holiday pay should help prevent contractors pushing for engagement via non-compliant umbrellas. Staffing supply chain. Sorry, go on.
Yeah, no, Shaz, go ahead. Sorry, I've just seen a few questions come in, but please go ahead, Shaz. Thank you.
I think I was just going to go on to the staffing supply chains that rely on cash flow funding. So there are certain umbrellas who do provide that cash flow funding to supply chains. So the umbrella company does pay the worker before being paid by the agency or the end client. And for those, they may need to find other sources of funding, with invoice discounting arrangements potentially being part of the solution. However, with joint and several liability in the background, we don't actually know how asset-based lenders how willing they'll be to lend to agencies and MSPs if they're going to become jointly and severally liable for the umbrella company tax compliance. We might see some movement of workers from umbrella companies that have been prohibited to other umbrella companies or in-house, either through the direction of the agency or the MSP who wants to reduce their risk by directing the use of a specific umbrella, or we might just see umbrella contractors moving to another by their choice when they're told they can't choose a certain umbrella company. This all just needs to be carefully managed just to ensure there aren't any unintended consequences. So we don't see this being a big problem, but there might be accrued liabilities that might pass over with workers if there's an attempted forced migration. Undoing risky legacy arrangements may not be straightforward, because case law suggests that if umbrella company workers are treated as like your chattels and they're moved around sort of at your whim, so you as the agency, then client can just say, you do what I want you to, then really they were never the employees of the umbrella company, and they were really the employees of you, the agency, or you, the end client. And if so, that raises some complex questions around who is liable as the employer. It's a very, niche legal point, but just raising it because it is one that could be raised. We also anticipate an increase in PSC arrangements. I mean, there's evidence looking at the ONS report from last year that in the past year there's already been a substantial increase in self-employed contractors. There are various reasons for that, and it's very unlikely to be this legislation yet, but this is likely to add to that shift already. I think it will be like the opposite effect of what we saw in 2017 and 2021, where we saw a shift towards umbrella company arrangements. Obviously, in our view, the shift is only worth considering where the arrangement is genuinely one that is self-employment. It's also important to remember that IR35 is still there and still being enforced. Um, we suspect whether or not there'll be a broad movement to PSC contracting may well depend on whether we see any high-profile IR35 assessments raised in the next 12 months or so. We have seen another public sector enforcement recently, but still no private sector news. We know it's bubbling in the background just from who we talk to. It's just there's no big public blow up yet, which means that some people might start to believe that it's a lower risk option. And combining that with the recent employers' national insurance rise and the element of statutory defence that IR35 has compared to this legislation, where fraudulent documents have been provided, PSE engagements might start to look like the more attractive option, even if in reality we think they shouldn't be considered.
Shaz, it's so impressive what you've just said, and I really like your take on potentially the growth of PSEs, and that does make sense, right? Because then you've got a whole host of reasonable defences, and
Yeah.
crucially, the tax is being paid correctly. Now, if you're engaging a proper umbrella, then of course the tax is being paid properly. But I really like where you're going with that. The question I had, Chaz, and listen, we hadn't prepared for this, but we did cover it in our podcast. But the thought occurred to me when I seen some of the questions in the chat, and we will come on to the questions, guys, and please continue to put them in. Is did the UK government, miss a trick by not introducing a licensing or bond regime, like for example that they have in Spain or Italy, where essentially the provider is putting money at risk, right? And there's a whole due diligence effort and licensing effort up front. If you look at Belgium, for example, you need a license in this region, the other region, and the third region, or Germany, you have to hold an IUG labour license. So, like Shaz, it's more just your opinion. Do you think a trick has been missed in respect of that, or do you think it's good that this is sort of going to police itself?
It depends on whose perspective you're looking at this from. So, I mean, obviously, it would be a lot better for staffing companies and other suppliers if they could rely on a licensing regime that also gave them the benefit of the defense. And in my mind, as a lawyer, that feels fairer as well. Like there's something you can look at, rely on. It's been licensed. It's not really your fault if you've done all your due diligence. If you're looking at this from the perspective of HMRC, whose main objective and only objective is to obtain as much missing tax as possible, I mean, HMRC, that's their goal, that's their only reason for being. This legislation is incredible for them. There's joint and several liability. They can go after someone with bigger pockets. There's no defense. It's a strict liability, offense for them, this is great because they don't have to get into much debate. It's really difficult to argue with. All the expense that goes to us lovely lawyers. There's less of it because it's clear. It doesn't matter if you feel wronged. The liability sits there. So I can see why HMRC and the government have gone down this road, but obviously I believe it's not necessarily the fairest road, but it's them who wrote this legislation, and for them, they've got the best outcome they possibly could.
Yeah, I think that's completely fair comment, Chaz. If you're HMRC, this
It's
is this is
great.
this is unreal. But if you're the operator in the middle, or indeed any part of that supply chain, then it's potentially problematic if you're engaging in short, dodgy companies that don't meet the criteria. Shaz, I think we've covered pretty much the strict liability aspect, but I think you've just summed it up really well there. There is no defense to getting this wrong.
No,
Yeah,
sadly not.
which sadly not. So I suppose just to reinforce that. So Shaz, just it's almost a hard one to answer then, but like what does a compliant umbrella look like in your view, right? Based on the legislation, the case law that exists out there, and your experience.
I think I'm going to start with a compliant umbrella company under the new rules looks like a compliant umbrella company under the existing law now. The fundamentals of what compliant is hasn't changed, but the consequences for everyone else in the supply chain where there is non-compliance has. So this does mean, and I am really piling on this point, no amount of due diligence will save companies from joint and several liability, but due diligence on umbrella suppliers will continue to be vitally important. I mean, critically, it does still weed out the bad actors. Whilst it's no defense if something goes wrong, your due diligence makes it much less likely that something will go wrong. Additionally, there are other things you're looking out for other than employment tax liability that make it really important to check out your suppliers. There's still the Criminal Finances Act to comply with, the defence for any offence for failing to prevent the associated persons of yours from criminally facilitating tax evasion, and I'm sorry that's a mouthful, it's not me who wrote it, is undertaking reasonable checks on your suppliers. There's also other due diligence issues you want to be looking out for, such as national minimum wage and modern slavery. So in practice, a genuinely compliant umbrella company should be able to show clear employment contracts with workers, consistent PAYE treatment, statutory rights, transparent pay slips that clearly show taxable pay, NICs, holiday pay, umbrella margin, and other deductions, with that pay being above national minimum wage. Evidence and all those other bits should tally up, if that makes sense, to the wage that's paid. So the taxable pay needs to tally up with the deductions, needs to tally up with the holiday pay. It should look sensible, not just like one number is completely out of whack. Evidence that the POA and NICs deducted have actually been paid across the HMRC. So it's not just that they appear on the pay slip, there should be some sort of evidence that they have been remitted. Robust policies on holiday pay, national minimum wage, expenses and working time, and then operational transparency so that agencies and end clients can understand how workers are engaged and paid without being given conflicting stories. So with a lot of the dodgy umbrella companies I've seen over my career, it does tend to be a story that's then rode back on, then re-given, and if it feels off in your gut when you're looking into it, there's probably a reason it feels off in your gut, and your gut is great. Like, trust your gut. We have been seeing a takeoff in new-ish accreditation platforms, so who offer to carry out in real-time checks into whether an umbrella company made the correct deductions and whether the corresponding payments of all sums due to HMRC have been paid. I imagine a lot of compliant umbrella companies will have this accreditation. I'm not saying that they have to have this accreditation to be compliant. I'm just saying I imagine a lot of them will. And I will say that all checks provide a useful tool to help lower the risk of engaging with an umbrella company. But with this legislation, we always have to state no amount of checks fully removes the risk. The joint and several liability remains, irrespective of how much you've checked the provider. So I think any accreditation or due diligence tool is a bonus, and it's a bonus that helps reassure you and helps you sleep at night. But you should still keep your own due diligence procedures in place to further support these checks. Some accreditation providers we're seeing also backed up by an insurance policy, and that will pay out to the agency or end client in the event the umbrella company defaults on the tax. I think some are going to be launching in the next week or so, maybe month or so. We've seen some already launch. Some users of umbrella companies may find this preferable to an indemnity from the umbrella company, which will only be as good as the umbrella company is financially sound or able to meet the liability. With any insurance product, whilst it may seem preferable, the key will always be to check the fine print and the cover offered. Will this in fact provide enough cover, and will that cover be for the right things?
Well, okay, Shaz, great tips and advice there. So, Shaz, like if I think back to IR35 in the private sector, like everyone was talking about it, everyone was focusing on the dates, and I know the dates did move for good reason. But there's been less of a clamour around this legislation, notwithstanding some of the tax that is likely to be clawed back that you mentioned at the outset of the webinar. But like if I look at Google, there's really only two organizations talking about this that are ranked, which is your own Osborne Clarke and CXC, and that's no plug, but it suggests to me that this has been somewhat under the radar, at least in terms of Google searches and organizations talking about it. Why do you think that is, Shaz? I think it's probably something to do with the end user is less at risk, right? There's less of an onus on the end user to run change management and governance programs, but maybe that's just overly simplistic. What's your take on that,
No,
Shaz?
I think that's a really good point. I think part of it might be that there's less risk on the end users, and because of that, there's less, awareness. And even when suppliers are banging the drum with IR35, they could bang the drum and say, you need to be providing us with this status determination statement. And if you do not provide us with that status determination statement, you are going to end up holding the baby. And obviously, that was for some enough to get them listening. I think the other thing, if I'm honest, is just a lot less people understand what an umbrella company is or even understand that it exists in the supply chain. So with limited company contractors, everybody knows that there's contractors in your supply chain. You're like, well, they're the people who, are self-employed and they do this project or they do that, and we've hired them for this, or they're in IT, and there's enough awareness that they exist in your supply chain. But realistically, once a client gets an MSP or they get a supplier directly, whichever way route it is they've gone down, they just assume that the MSP is or then directly engaging, or there might be some, sub suppliers, but they don't think of an umbrella company because it's not something that naturally fits into anyone's mindset as to what a supply chain should or needs to have. So it may also just be a case of people are unclear on what it is, and sometimes when people are unclear on what it is, rather than deal with the problem, they just shut it out and don't.
I think that's spot on, Shaz. So, Shaz, we've covered some of the best practices and what good looks like. Anything you want to add to that before we move into the questions?
I'm very good, actually. We can
Okay.
more than happy to move on to questions.
Okay, excellent. Well, I'll start with what might seem like a straightforward one first, and that is from Sophie Lee's. Okay, yeah. So I think Sophie's question is the following: do you have a few Shaz on services such as the FCSA or professional passport to support with the due diligence of the umbrella companies? And I'm paraphrasing somewhat.
Um, I mean, I don't take a view on which is better or which is worse. I take a view that all due diligence tools are an excellent tool to have. Anything that helps you bolster your evidence and, helps you, because I'll be honest, undertaking the due diligence that's required on umbrella companies to ensure that you are absolutely certain that you're not going to have any liability, I think that's impossible. But even to get to the point where you're 95% happy that you're not going to end up with a non-compliant umbrella, it's a lot of hard work. It's constant payslip auditing. It's constant checking the remittance to HMRC. It's at least a proportion of 10 to 20% of your pay slips, and you're starting to get into the realms of requiring 3 or 4 employees just to keep on top of this, and it's a lot. So I think compliance checkers and tools have a real important place to play in your supplies. It's just I wouldn't necessarily rely wholly on them.
For a comment, Shaz. And Sophie, thanks so much for your question. We've got a really interesting question also from Ray Walker. Ray, great to see you and everyone else on the webinar today. So Ray's question, Shaz, is the following. Can you expand on the new addition to purported umbrella companies? I believe Shaz said it will include staffing companies who engage a worker but who have not performed the job matching service. Does that mean agency workers found by the client or another party but employed by the staffing supplier would be considered a purported umbrella company arrangement under Chapter 11? Great question, Ray. I'm looking forward to Shaz's response. Thank you, Shaz.
Yes, essentially. So I think the idea is the only workers who should be engaged on the sort of Chapter 7 PAYE basis are those where agencies have provided work finding services, where a client has referred, individuals they found to you. Um, Feel free to employ them as your, the contract of employment type sort of sub arrangement, or if you do engage them on the contract for services, what this new legislation is saying is for those individuals, you'll be treated as an umbrella company.
Thanks, Shaz. And Shaz, I think we've one final question from Richie Smith. Hey, Richie, how are you doing? Which is, I'm just going to go back in the chat. Yes, Richie's question relates to insured services. So Richie is saying, will this herald in an age of insured services? And I think what Richie might be referring to is what you mentioned earlier, Shaz, but also what we observed during IR35 rollout private sector was a whole host of insurance related products around that. But over to you, Shaz.
I think in a manner similar to the IR35 legislation, yes, we're starting to see the usual providers start to get to grips with what it is they need, start to prepare their products, starting to come to market. So yes, we are going to see some insurance around this legislation. I just think it's probably going to be harder for the insurer to feel comfortable with this legislation, considering it's a strict liability, joint and several, liability. So with IR35, there's a whole host of arguments that insurers can get into to try and get out of having that liability, whereas here, obviously, there's not. But we are starting to see that market pick up.
Great stuff, Shaz. Shaz, thank you very much, and thanks to our audience for joining us. But thank you for all your expertise and showcasing that. Of course, today isn't intended or should be construed as legal advice from you, Shaz, or Osborne Clarke. But if anyone is interested in delving into this further, please do reach out to Shaz, Shaz Kurmani, Associate Director at Osborne Clarke. We also have a QR code here, guys. If you want to scan it in relation to our quarterly risk report, which would be delighted if you could join. Sorry, if you could take a picture and download the report. We'll also be following up with a recording of today's webinar along with a handy guide as well in relation to the umbrella reforms in the UK. Shaz, thanks so much for joining us today. Thanks so much for our audience joining us today. If you have any follow-up questions, please do drop Pete Botto, who organised today from our marketing team. Thank you, Pete, also, and we'd be delighted to answer any questions you may have. With that, guys, we'll give you 17 minutes back. Thanks for the support on the webinars. And Shaz, thanks again. Have a great evening, everyone. Appreciate it.
Thank you.